afternoon. We're here for docket number 4627. And we are dealing with NextEra Energy Resources LLC's motion to compel and also general redaction concerns. Could the parties identify themselves for the record, please?
Good afternoon. Joseph Keel on behalf of NextEra Energy Resources LLC. With me to my right is Amy Jameson, Senior Attorney for NextEra Energy Resources LLC.
For the Narragansett Electric Company, John K. Abbott with the law firm of Keegan Rowland LLP, Boston, Massachusetts.
Steve Boyajian on behalf of Algonquin Gas Transmission LLC.
John Hagopian for the division.
Good afternoon, Mike McElroy for the Lieutenant Governor.
Cynthia Wilson-Price, Commission Counsel.
Alan Knoll, Commission Radioist.
Todd Bianco, Commission Policy Associate.
Very good. Are there any administrative matters we need to address before we go to oral argument?
I don't think we have any exhibits to mark at this time, as this issue surrounds motions and objections. I think if the first part of the hearing would be on NextEra's motion to compel, and the second part would be on the redaction questions that were contained in the August 5th, 2016 memorandum that I sent to the parties. At that point, we may have some exhibits, as it's my understanding that Narragansett Electric and Algonquin have agreed to making some further information public. And then I do think we'll have a couple of questions on some general questions to make sure that we have a clear policy going forward on the level of redaction. And so what I told the parties was that the first part of the hearing would be a traditional oral argument for the commission. And I don't know if you've set forth time limits, Chairperson, but then the second part will be a review of the revised documents by the commission, and probably more of a back and forth discussion with potentially, I believe each party brought witnesses in case there are factual questions that would be best left to company officials.
How much do council think they would benefit from the argument? Tom?
3 hours. I don't anticipate it being overly windy, although I never do. I don't think I'll do that long.
10 minutes?
Take 10 or 15 minutes.
Would.
Don't hold me to it. Let's go.
No, I'm not.
Let's go 15 then.
Okay.
Because last time I asked for a shorter time, I got it.
Same, Madam Chair, 15 minutes, and there was counsel for Algonquin, I'm assuming, and I would encourage giving time to Algonquin also.
I don't anticipate that would be more than 10 or 15 minutes. So 15 would be fine.
Also, Attorney Jameson is here to answer any questions that the commission has. I know there was specific issues within the commission's memo directed to NextEra, so she certainly could answer any questions that the commission has.
Anything else? NextEra.
Good afternoon. Thank you, Chairperson Curran and Commissioner DeSimone. I'd like to begin by addressing the issues raised in National Grid's opposition and the issues that are before the Commission in a general and high level before addressing some of the specifics of National Grid's written opposition. First, National Grid relies heavily on the Massachusetts DPU rulings on confidentiality in support of their objection. There are two problems with this reliance, and they may seem rather obvious, but This proceeding is taking place in the state of Rhode Island, not in the Commonwealth of Massachusetts. The state of Rhode Island has its own unique Access to Public Records Act and its own unique societal and political issues. The stated purpose of the Access to Public Records Act is as follows. It is essential to the maintenance of a democratic society that public business be performed in an open and public manner, and that the citizens be advised of and aware of the performance of public officials and the deliberations and decisions that go into the making of public policy. The Attorney General's Guide to Open Government in Rhode Island, 6th edition, states as follows. The Open Meetings Act is a chapter of the Rhode Island General Laws designed to ensure the people's business is conducted in an open manner so that the public may participate in their government and so that government will be accountable to the public. By conducting the public's business in an open forum, public bodies gather input from citizens concerned with the decisions being contemplated. By observing and participating in their government's decisions, citizens of this state gain increased accountability from their elected and appointed representatives. This statute, I believe, is especially critical in the state of Rhode Island. All one has to do is pick up the Providence Journal on any given day and read about how citizens of the state have lost faith in its elected officials due to government actions that take place in closed and private manner rather than an open and public manner. We're still reading articles about 38 studios to this day, and I don't think those articles are going to end anytime soon. The proposal by National Grid in this case is extraordinary. They are asking for electric customers to fund gas pipeline expansion over a 20-year period and assume that the risk of that investment will result in lower costs. National Grid has also asked for a bonus payment for its alleged innovative efforts in submitting this proposal. So it's the public's money that is at risk here. Yet National Grid seeks to keep much of the information supporting its request out of the public record. The second problem in relying so heavily on the Massachusetts Department of Public Utilities decision is again obvious. But this proceeding in this docket is taking place before the Rhode Island Public Utilities Commission, not the Massachusetts Department of Public Utilities. This commission has its own unique rules of practice and procedure and its own culture. And this is a culture of one that is one of openness and transparency. The refreshing aspect of discovery in this forum is that things are open and transparent. I'm sure that both of you as litigating attorneys in another time and place can appreciate this. When data requests are asked, they are answered. When testimony is due, it's submitted. They are then posted on the Commission's website for anybody to see. It stands in stark contrast to what would happen in a typical Superior Court litigation, where more times than not, the first answer to an interrogatory is objection, overly broad, unduly vague, burdensome, and not calculated to lead to the discovery of admissible evidence. Then the haggling begins between the attorneys, and then you end up on the motion calendar for half a day trying to resolve these issues. That doesn't happen here. And the reason for the transparency, I believe, is that unlike in Superior Court or in other courts, the outcome, where the outcome only affects the litigants themselves, the outcome of cases before the Commission affects ratepayers and it impacts the public interest. That being said, the Access to Public Records Act does recognize that certain information should not be disclosed publicly, but it has limited exceptions. And they are the exceptions, not the rule. At this Commission, we have a process for dealing with these exceptions that allows for the efficient litigation of these dockets. A party does have the right to mark information as confidential. The Commission usually makes a determination that the information can remain confidential, but all the parties get to view the information subject to a mutually agreeable non-disclosure agreement, confidentiality agreement. This allows the parties to develop their testimony and make a decision as to whether they should challenge the claim of confidentiality at the hearing. This approach has been followed to a certain extent in this docket, but not entirely. First, National Grid asked for a two-tiered confidentiality designation: confidential information and highly sensitive confidential information. There is no provision for this two-tiered designation in the Access to Public Records Act or the Commission's Rules of Practice and Procedure. And in fact, the Commission has already rejected this two-tiered designation. Second, as the Commission sua sponte raised, it would seem that National Grid has applied a very liberal brush to information it considers highly sensitive, confidential information. Third, National Grid has proposed a non-disclosure agreement that contains a provision that I have never seen in the many dockets I have litigated before this Commission. They actually want to prevent attorneys, in-house attorneys, or an intervener from viewing what National Grid considers highly sensitive confidential information. Again, there is absolutely no provision for this in the APRA or the Commission's Rules of Practice and Procedure. So I'd like to specifically address some of the issues that National Grid raised in its written opposition to NextEra's motion to compel regarding this exclusion of NextEra's attorneys from viewing the highly sensitive confidential information. National Grid in its papers correctly states that I, as outside counsel, requested that 4 of NextEra's in-house attorneys and its Director of Regulatory Affairs, also an attorney, be included in the non-disclosure agreement, and that they be allowed to sign the non-disclosure agreement and be subject to the terms of the non-disclosure agreement. Here's what National Grid says in its written objection on page 4. National Grid declined to include such a provision as it essentially negates the reasonable dissemination parameters of the highly sensitive confidential information non-disclosure agreement, rendering the non-disclosure agreement worthless. Think about that for a moment. The only way that that non-disclosure agreement for highly sensitive confidential information becomes worthless is if those 5 attorneys, all officers of the court, all subject to professional and ethical obligations, violate the terms of that non-disclosure agreement. So National Grid, in claiming that the non-disclosure agreement becomes worthless if NextEra's attorneys are included, presumes, without any basis in fact or law, that they will violate the non-disclosure agreement. National Grid goes on to argue that accordingly, both NextEra's outside counsel and expert consultant have the requisite proficiency to review and analyze the highly sensitive confidential information and to assist NextEra in deciding upon and supporting its claims and proposals. So they're saying that both myself and the experts at Compass Lexicon can view this highly sensitive confidential information and advise our client. Now, they wrote that on page 8 of their memorandum. But on page 9, I'm going to read this in its entirety because I think it's important and it highlights the real issue here. Under the terms, and I'm not going to use the abbreviations, Chairperson Carden, so it won't be a direct quote. Under the terms of the highly sensitive confidential information non-disclosure agreement provided to NextEra's outside counsel, both NextEra's outside counsel and consultant are authorized to consult with NextEra and allowed to rely generally on their examination of the highly sensitive confidential information to provide strategic guidance to NextEra regarding this proceeding. Here comes the but. Provided, however, that in rendering such guidance, advice, and otherwise communicating with NextEra, NextEra's outside counsel and consultant are prohibited from disclosing any confidential information pursuant to the highly sensitive confidential information non-disclosure agreement to NextEra. In this manner, internal NextEra attorneys and Director of Regulatory Affairs will be able to determine how the National Grid request for approval of a precedent agreement with Algonquin may impact their specific businesses or business and market interests. This makes absolutely no sense. Neither I nor Compass Lexicon can even discuss the highly sensitive confidential information with our client. And yet, National Grid argues that they will be able to determine how its request for approval in this case affects them. There's simply no way to do that. National Grid goes on to claim that I have extensive experience before the commission. That may be true. But I am not an expert on the intricate matters that are litigated in this docket. Compass Lexicon also has experience in energy issues. But you cannot cut the client out of discussions regarding the litigation of a docket. To do that severely impacts the client, their interests, and their due process rights. Now, National Grid argues that...
I have a question,
Yeah.
Mr. Kim. What is NextEra's interest in this proceedings?
The interest is an objection into the proposal. If we want to get into more of what what National Grid claims their interest would be in disclosing this information, we can have Ms. Jameson.
What's NextEra's interest in the information?
The information produced in this docket, as I would talk about in Massachusetts, is certain information. In fact, almost all the information produced by National Grid in the Mass docket has been marked highly sensitive confidential information. And the point that I would get to is that not only is it the material that they mark highly sensitive confidential, it's anything that flows from it. And so in order for an attorney or an expert to advise the client, they need to be able to discuss that type of information with them. And that is the problem here. And again, it would be subject to the non-disclosure agreement, so that we have a very finite set of attorneys viewing it and advising their attorney and an expert, not disclosing it to the remainder of the company.
Doesn't it?
But what's NextEra's interest in this particular matter?
May not be understanding that, Chairperson.
Well, they've been granted intervention.
They're an intervener who opposes this proposal for a number of reasons. And they believe that this proposal, it's like any other intervener in any other case. You know, interveners come in and they provide valuable input to any docket. They may raise issues that the division doesn't raise. They may raise issues that other people haven't thought of. NextEra opposes this proposal for a number of reasons that will be elucidated in the testimony. But this issue is just whether their in-house counsel can view this information and work with their attorney and their client.
I guess I'm having trouble, though, understanding what interest NextEra has in these matters, and particularly in the information that's redacted that is outside of NextEra's interest in understanding in this regional area that is being done, that is being addressed in a number of states individually, certainly, but beyond that interest.
I don't believe there's any interest that they have that would be assisted, first of all, by allowing their in-house counsel to view this information. And again, it would be viewing this information subject to the terms of the non-disclosure agreement. So I don't think there's any interest that they have outside of this docket or outside of this proceeding that they're looking to advance by looking at this information.
But all this information relates to proposed terms to a contract that is not signed, hasn't been approved. Seems to present a very different kind of situation than we see in really any other docket or matter.
Well, I agree, and I think that that's what typically, in any other docket, use for an example, the Deepwater docket that was highly litigated. There was information in that marked confidential. But there was no prohibition on any attorney, in-house, external, being allowed to view that information because they were subject to the terms of non-disclosure agreements. And so in that case, you could say to any of the interveners, well, what interest do you have in whether or not this gets billed? But their counsel and their experts were allowed to view information that was marked confidential. There's never been, that I know of, an exclusion on an attorney who's willing to sign a non-disclosure agreement from viewing information to help litigate the case. And if NextEra had no interest whatsoever, they would not have been allowed to intervene in this case.
I'll agree with you. In 35 years, I've never seen a provision like this where in-house counsel is precluded from seeing confidential information. Doesn't this put you in a precarious position as outside counsel? Because now you obviously have to communicate with in-house counsel. You have to discuss strategy with them. You have to discuss the facts of the case with them. And you're not able to fully do that, are you?
And I think Ms. Jameson can probably answer some questions on what the experience has been like in Massachusetts, but just to give you an example, as National Grid points out in their brief, they say that, look, it hasn't had any impact in Massachusetts because NextEra has been able to issue data requests, NextEra has been able to produce testimony. The problem is, in-house counsel cannot even view some of their own testimony, and that's because it flows from the highly sensitive confidential information. So I'm left at a severe disadvantage in not being able to communicate to the client or ask the client questions, or it's a severe disadvantage.
You can't basically give the client the full story, can you?
You cannot.
No, this piece is missing in the jigsaw puzzle, correct?
Correct.
And you're left to hint at them, probably.
And frankly,
Which could get you into
I would be on
danger.
I would be on the very cautious side of hinting. I can tell you that even we've issued some data requests, and I have to be very careful that the data requests don't quote highly sensitive confidential information. And I can't talk to in-house counsel. I have to talk to the expert at Compass Lexicon, and they're not an attorney. And so it creates a number of problems.
And as outside counsel, you don't make litigation decisions on your own, do you?
I think of it this way. If you think about a building, I might be the contractor, but I need an architect. I need someone who knows the whole picture, who can direct me. I can't make those determinations on my own. I would be flying by the seat of my pants and not being able to advance my client's best interest because I can't tell them what's going on.
Well, the client has to be thoroughly involved in all decisions made during the course of litigation.
Correct.
And really, that's hard to do when you can't fully communicate all of the facts to the client.
I would say it's impossible.
Chairperson, could I ask a couple of questions? Mr. Keogh, first, and I'm going to split the Director of Regulatory Affairs out in this question. right now there's 5 people listed, one of whom is the Director of Regulatory Affairs, who I know it says is an attorney. I think that that position would give me pause more than any of the others, because as the Director of Regulatory Affairs, that person is required to know what's going on in all states and to advise the company as to the impact in all states where there are operations going on. And so I would think that it would be incredibly difficult for that person to do their job and comply with such a non-disclosure agreement. Do you have any comments on that particular position?
I think that maybe that for this specific piece, Ms. Jamison would be the person to address. She can tell you what their roles are in the company. Again, better than I can. So if you want us to swear her in, we can certainly do that.
Raise your hand. Please swear the testimony you're about to give today with the truth, the whole truth, and nothing but the truth.
I do.
And please state your full name for the record.
Amy Jamison, Jamieson.
Thank you.
So to your question about our Director of Regulatory Affairs, that's correct. She works in the ISO New England market generally. So she, as frankly I am, is involved in this matter throughout New England. I think the issue here is that she's not involved in commercial negotiations regarding LNG pipeline development or any of the issues that Algonquin and National Grid say that they're concerned about. So she's advising on, for example, how the ISO New England market works, because I'm not an expert in that. But she's not, providing advice to the business folks on pricing gas or anything like that helps make that distinction.
So why would it be important for her to have the inputs into how the pricing of the capacity or the pricing models or the cost savings models? How does she need that in order to advise the company on how the ISO New England market works?
I think it's not so much having, for example, the models. I'm not a modeler. I don't use that. But, for example, the National Grid has redacted the cap amount for this contract. So any discussions I have with our attorneys or our experts about the outcomes of our model runs, how different assumptions might change those, I frankly cannot have those discussions openly, because I'm not permitted to have access to any of the information that flows from that. And so the same would go for our Director of Regulatory Affairs. To the extent we're talking about how the models might change based on inputs, then she's not able to have those discussions based on how National Grid has conducted their redaction.
And why does NextEra need that particular information in order to oppose this before the commission?
In Massachusetts, we've presented expert testimony from Compass Lexicon that analyzes the Black and Beach study that National Grid has provided and conducts our own 2 different analyses of the costs and benefits. And so our testimony provides evidence that, in fact, the costs are higher than the benefits. And I know that our testimony says that, but I can't see the numbers and have discussions with them about what those specific numbers are and how they change and frankly how they got there. So that's how it's been challenging in Massachusetts.
Why do you need 5 attorneys to look at this? I feel like once you get, it's the only way I'm going to keep a secret is to not tell anybody.
Right.
And the more people I tell and ask to keep quiet, the harder it is to inadvertently, not inadvertently release that information, or to use that information in such a way that might have an impact that it shouldn't have. And so, why 5? That seems like a lot.
Okay. And we can certainly talk about limiting that list further. We went through and tried to identify anyone. For example, Mitch Ross is our general counsel. He's essentially my supervisor on these matters. he's not looking at model runs, but there might be a circumstance where I need to get his strategic input on a big picture issue that flows out of information that National Grid has redacted. Bill Lavarco is our internal FERC gas attorney who's familiar with precedent agreements and the terms and conditions around those. It's possible that I could seek his input. Brian Murphy is my counterpart in my department in the state regulatory group. So if, for example, I'm on vacation or, I can't be in two places at once, he might step in, and I wanted to be sure that, his hands weren't tied if that was the case. And Michelle Gardner, for the reason that I just explained, that she's familiar with the ISO market. But if you were uncomfortable with the number of folks listed, I think, we could take Mitch Ross off that list.
And he's which one?
He's the general counsel.
How many in-house legal counsel do you have?
Total for NextEra and its affiliates, I think it might be around 100.
Now, you said one of the attorneys is familiar with FERC precedent agreements. Is a FERC precedent agreement, is that something that NextEra would have with anybody?
Yes, we would, yeah.
Okay, so how does this attorney then take that information and not use it in a competitive situation down the road? You have that knowledge of a duty to your client, and now you're going forward to engage in negotiations. This case is long over. How do you not use that information? How is that not advancing NextEra's competitive interests over another company?
So I think what you need to have that competitive harm is a situation where NextEra was then going to negotiate an agreement with either Algonquin or National Grid and say, well, you use this term here, how about this term here? NextEra did not respond to the RFP in either Massachusetts or the more recent one in Connecticut, is not developing a pipeline in New England. So it's hard to understand how understanding those terms could harm either Algonquin or National Grid.
NextEra has generation supply though, correct?
That's right.
Okay, so, and Algonquin has space on the pipeline.
Yes, and we do have and that's one of our interests in the proceeding, is that we have a natural gas plant in Massachusetts that takes gas from the Algonquin pipeline.
And so NextEra would be engaged in negotiations down the road with Algonquin, correct, for pipeline capacity at some point? In terms of even if it's non-firm?
It's our position that, and we filed testimony in Massachusetts, that we would not be interested in taking capacity under the terms proposed here. I don't, perhaps we'll get more information from National Grid and Algonquin, but it's hard for me to understand how, knowing and in particular, I'm mentioning the cap amount in the contract because that has been the most difficult thing in restricting our ability to talk freely with our attorneys and experts. I don't understand how knowing that information could be used by our gas plant to the detriment of National Grid or Algonquin.
Did you say that NextEra has not responded to any of the RFPs in the Connecticut proceeding?
We did not respond to the natural gas RFP in the Connecticut proceeding. We did respond to the clean energy, the New England wide RFP, and then the smaller storage RFP in Connecticut. But again, I've struggled to think of a way that, those bids are in, they're being analyzed. Even if there was some way to reopen the bids, I don't know how, knowing, for example, the capped price on this really massive natural gas project could be used by NextEra, in a 20 megawatt storage project against Algonquin or Grid.
Yeah, hearings are currently ongoing in Massachusetts, correct?
Right.
Okay. And I'm assuming the DPU usually has a briefing schedule set up, so I assume they're going to have briefing.
That's right.
Okay. A lot of this information was kept confidential in Massachusetts. How do you not use that information if this commission were to determine that that information should be public in Rhode Island, or not public, I'm sorry, I misspoke, should be available to in-house counsel?
I think that, and I know Algonquin addressed this, but if the concern is our in-house attorneys inappropriately using this information for commercial gain, that's a different issue than litigating regulatory proceedings in Massachusetts. We can still abide, we'll have the NDA, we cannot provide it to our business folks. We won't provide it to our business people in Massachusetts, Rhode Island, or any other context. But I think the idea that it's inappropriate for us to get the information in Rhode Island because then we can litigate more effectively because we can talk to our Rhode Island counsel. I don't see how that's an appropriate reason to keep us from getting the information if there is no concern about a commercial competitive interest.
Are you using the same consultant in Rhode Island that you used in Massachusetts?
Yes.
Mr. Keough, are you aware of any other case at the commission where a competitor has been allowed in and has been able to get unredacted material?
I can't think of off the top of my head where a competitor has gotten unredacted information, but I think that the unique situation here is we're not asking for the competitor to get unredacted materials. We're not asking that this information be shared. We're not asking that this be an email blast go out to the company at NextEra saying, look what we got. We're talking about a finite number of attorneys who would be glad to limit if the commission saw fit to seek a limitation. We're talking about those attorneys using the information subject to the terms of the NDA, which include no electronic copying, return at the end of the case, contains a number of provisions. So we're talking about a small number of attorneys being able, I think as Ms. Jameson put it, it's not so much that I'm a lawyer, she's a lawyer, she's not going to dig into the models. But the problem is, and let me just read something from National Grid's papers, because this, I think, makes this point. National Grid claims that there are a number of categories that fall into the highly sensitive confidential information category. This is on page 10 of their memorandum. Bid information, including the information contained in the winning bid that was used to develop the confidential price and other terms of the precedent agreements with Algonquin. 2, analysis regarding bid information. And 3, proprietary models and associated inputs and assumptions. Now, some of that information you would typically see as a subject of a motion for confidentiality agreement, proprietary models. But the next sentence is what is unique. These categories, the 3 categories that they enumerated, extend to analyses developed by the companies, such as bill impacts, utilizing the original highly sensitive confidential information. So, at first it seems reasonable. You have these small number of things that are redacted, and that seems reasonable and seems in line with what we do here. But any information that flows from that cannot be viewed by in-house counsel. I have a copy. I would urge the Commission to ask a record request of National Grid's privilege log in the Mass DPU docket. Almost everything I've looked at is labeled highly sensitive confidential information, not confidential. Now, confidential information can be shared with the client. Highly sensitive confidential information cannot be. So almost everything that has been marked as HSCI. So once you allow this provision, once you allow National Grid to control what they mark as highly sensitive confidential information, without me being able to review it with in-house counsel, it's very difficult for me to even challenge that assertion that it's highly sensitive confidential information. So I'm not looking, and Nextera is not asking, for this information to be provided to a competitor. And again, I go back to the point that I think that the Commission has to assume that attorneys who are officers of the court and bound by ethical and professional obligations will follow the terms of the NDA. There's really no other way to read it other than to say they're going to violate it. And I don't think that has any basis in fact or law. I mean, you're talking about them having access to information so that they can advise on the litigation of this document. It's not to be used throughout the company.
Ms. Jamieson, could you just give us your position with NextEra for the record, please?
For the record, I'm senior attorney for NextEra Energy Resources.
Okay, and what bars are you admitted to?
I'm admitted to the Oregon bar, and I'm admitted as in-house counsel in Florida. They have a separate designation for in-house attorneys.
Okay, and where is your office, if I may?
It's in Juno Beach, Florida.
Okay, and how long have you been practicing law?
I've been practicing law since 2005.
Okay, and are you in good standing in all the states in which you're admitted?
Yes, I am.
Thank you.
I just have one final point, and that's the precedent of allowing this type of non-disclosure agreement. Allowing non-disclosure agreements to exclude in-house counsel would set an awful precedent, and one that is completely opposite to the transparent manner in which this Commission always operates. National Grid argues that it will likely experience substantial difficulty in the future in negotiating with potential contract partners, and that the company's customers will bear the burden of higher prices. But this misses a larger point. National Grid, the proposals that come before this Commission must be examined in the most transparent manner because they do affect customers. National Grid cannot reach agreements with contract partners and then proclaim that key terms cannot be publicly disclosed, even to attorneys who sign non-disclosure agreements. They also should not be allowed to curtail the participation of interveners. As I said earlier, interveners in these dockets can serve an extremely useful purpose, one that is in the public interest, raising questions perhaps other parties didn't think of, raising issues that the division doesn't raise, and creating transparency in these proceedings by asking these questions and putting the utility through the test of having to justify their proposals. And to allow this type of NDA or non-disclosure agreement would have an adverse effect on interveners' participation in the future. Thank you.
Thank you, Mr. Hill. Did you have any preference on who goes first?
National Grid is happy to go first, Madam Chair. Madam Chair, Commissioner, thank you very much for having the oral argument today on a matter that I assure you National Grid understands the balancing that the Commission is dealing with in trying to resolve this question in this case. and we will be discussing after the oral argument, going through the information that has been redacted so far in the case, and with permission from Algonquin, unredacting certain aspects, while keeping the most crucial sensitive aspects of the materials protected, at least the argument that obviously. So I want to stress, obviously, that National Grid and Algonquin, speak for them so momentarily, want to facilitate your review here and balancing these interests of public disclosure versus protecting ratepayer interests in this docket. And that's the balance I think I'd like to stress. Just some general background as a reminder to the Commission. National Grid is here with this contract for the electric company to procure gas capacity based on several years of discussions with government stakeholders in the region and in New England. This idea came out of NESCO, which obviously the governor of Rhode Island at the time was involved in, and the current governor is still involved in, although those discussions were prior to this governor's administration.
You should spell stuff out for the record, at least the first time.
I apologize, yes. New England States Committee on Electricity. And obviously the passage of the law in Rhode Island a couple of years ago that allows and encourages voluntary proposals such as the one that's before the Commission that would allow electric companies to procure gas capacity to promote regional interests. And the interests that are being promoted by this contract is lowering wholesale electricity prices for customers and improving reliability in New England. And to go to the Chair's first question to Nextera, and I appreciate the sincere arguments that they made on the record here. Nextera's interest in this proceeding has nothing to do with ratepayer interests in Rhode Island. Nextera's interest in this proceeding as a generator that has benefited from very high wholesale electricity prices very recently, two winters ago, and continually, wants to maintain those business interests going forward. They're trying to keep prices high. They recognize that this contract represents the likelihood that wholesale electricity prices are going to be lower if it is approved in the states that it's currently before. And that I know Algonquin hopes are see this contract in the near future. So Nextera's interest here in trying to oppose National Grid's non-disclosure agreement not to have their in-house counsel look at this information is purely because Nextera wants every advantage that they possibly can. In the event that this deal doesn't go through, to be able to argue in other states where their affiliates have put in bids to provide electricity in other states, to potentially give those affiliates a competitive advantage over whether it's a similar pipeline project to this, if it doesn't go through, or other pipeline projects. And certainly through litigation of this docket in Massachusetts, as it's currently going on currently, having their in-house counsel see this information now, when the Massachusetts Commission has ruled that their in-house counsel cannot see that information because they have the balancing of public interest in Massachusetts, at least to date, has resulted in the Massachusetts DPU agreeing with National Grid that the risk of a competitive advantage going to Nextera, if the business interests at Nextera, including in-house counsel, access to information, is too great. That the line that the Commission has drawn in Massachusetts is to have Nextera's outside counsel and consultant be able to review this very highly sensitive competitive information. And the information, let's get to the crux of it, that we're trying to keep protected is the negotiated rate for this contract. And the negotiated rate for the contract, it flows through the docket in many areas, and we can get to why certain aspects of the docket have been redacted and their relationship to that negotiated rate. But to the extent that Nextera gets access to that information, both with regard to their advantages in other states potentially and the proceeding in Massachusetts, is only for the purpose of undermining this contract and undermining similar contracts that might happen in the future if this contract is not approved. The two-tier approach that we're asking for on Rhode Island creates consistency across 5 New England states that are either reviewing this contract or that Algonquin is seeking to have their contract reviewed. To the extent that Rhode Island decides differently in terms of protecting this information, even from in-house counsel, that potentially has ripple effects in the other states where this contract is currently being reviewed. And I would stress that is a key distinction between what maybe has occurred in the past in Rhode Island with contracts and contract information and who can see the information. There are currently competitive solicitations ongoing in New England. And this two-tier approach that National Grid is advocating for in Rhode Island is not meant to be something that would be prevalent throughout contracts that National Grid files in Rhode Island. And even in this docket, the two-tier approach has been agreed to and suggested by National Grid for people like the Lieutenant Governor's office because of public records risks. To the extent that there is material that is in the possession of Lieutenant Governor McKee's office that somebody asked for, there is a risk, obviously, that that information could be put in the public record. And their counsel has agreed that only their counsel will be able to see this information and strategically talk through issues with the Lieutenant Governor's office versus have that information in their possession. In Massachusetts, one of the competitors of Algonquin in the RFP, their Repsol, has agreed to this two-tier approach. Their outside counsel sees it, their inside counsel does not. Town of Weymouth in Massachusetts, a public entity, has agreed to this two-tier approach because they understand that if individuals in the town of Weymouth have possession of this information and a public records request was asked, there's a possibility it could be disclosed through that sort of request. And so for purposes of litigation in Massachusetts, all parties have agreed to this two-tier approach. And Nextera, while originally not supporting the two-tier approach in Massachusetts, once the commission ruled that the two-tier approach was appropriate, to my knowledge, and counsel for Nextera can correct me if I'm incorrect, did not appeal it, has not challenged it, has successfully litigated this contract in Massachusetts. We're in the middle of hearings. They're actually going on right now as we're having this argument in Rhode Island. Cross-examination of Nextera's witnesses is scheduled to take place the last week of this month. And if all of a sudden in Rhode Island it's determined that in-house counsel for Nextera gets to see information that the Massachusetts Commission has decided to date they should not see, is definitely potentially going to give it information to Nextera that they can use on cross-examination in Massachusetts that the Commission in Massachusetts did not give them permission to have access to.
Would that be a violation of their non-disclosure agreement?
It would be. Nextera has signed this non-disclosure agreement that we put before you in Massachusetts, and that they have signed subject to this argument, does not allow their in-house counsel to see this competitively sensitive information.
So are you saying that we are bound by the Massachusetts DPU decision? Is that what you're saying?
I'm saying, I am arguing, Commissioner, that you should be influenced by it. I can't argue that you're bound by it. You certainly have the discretion to rule differently.
And how are you going to be competitive? By you, I mean National Grid. How is National Grid going to be competitively harmed if Ms. Jamieson has access to confidential information?
So the National Grid can be competitively harmed to the extent that the very, very favorable negotiated rate that is in this deal and bid terms that are related to that negotiated rate, that Algonquin acceded to National Grid's request to accomplish this deal. If this deal falls apart because Nextera, unintentionally, I'm assuming that an attorney, in-house attorney for Nextera would intend to try to abide by it. If for some reason the information did get out to the business folks internally, and it ended up resulting in this deal not going forward in Massachusetts, and then Rhode Island, and then Connecticut, and then Maine, and then New Hampshire, the ratepayers of Rhode Island are going to be adversely affected by having their wholesale electric prices be potentially at very, very high levels versus what they could have had under this contract.
So you're not suggesting that the in-house attorneys are going to intentionally violate the non-disclosure agreement, are you?
I am not.
Okay. And after all, they are governed by ethical canons. There are disciplinary procedures that could be put into play if that happened. Isn't that correct?
It is correct.
Okay, so what you're saying is that, and correct me if I'm wrong, is that the more people who have access to this information, the greater the chances there may be some unintentional violation of the non-disclosure agreement. Is that what you're suggesting?
That is what National Grid is suggesting, yes, Commissioner.
Okay.
And so by maintaining this, by maintaining the line at NextEra between our outside counsel and expert consultants, and the business of NextEra, which includes their in-house attorneys, the National Grid certainly believes that that line is a reasonable line to make sure that there are no due process impacts on NextEra, and that the information that is competitively sensitive in these contracts can be maintained for full review by all the commissions that are going to be looking at this information going forward, hopefully to the benefit of customers.
Have any other states other than Massachusetts adopted this two-tier approach?
So the two-tier approach, so right now, Commissioner, in Connecticut, the RFP process is still going on. So there is no contract for the Connecticut PUC. I'm assuming Eversource is going to push this two-tier approach in Connecticut, but it hasn't reached that stage yet. And right now in Maine, this contract, my understanding is, the Commission has approved the review and development of this very similar contract in Maine. And although there was, I don't know for sure whether or not there was an issue in Maine with NextEra in particular. I'm not even sure if NextEra was involved in the Maine proceeding. But this information has not been revealed to individuals outside of the full parties to the dockets in the states where the deal has been put forward.
Now, you're outside counsel for
Yes.
National Grid. You wear that hat quite often.
Yes.
Okay. I assume you represent other companies
Yes.
as outside counsel. And in that capacity, I take it that you interact with in-house counsel for National Grid, correct?
I do.
Okay. And I take it that you don't make, that when it comes to developing litigation strategies in the course of a case that you communicate with your in-house counsel, whether you're representing National Grid or anyone else, is that correct?
We do.
And you need to fully communicate, is that correct?
That's true.
Okay, and you need to tell them exactly what all of the basic material facts are?
Yes, and they have access to it typically.
Right, and it's not up to you, or it's not your role to, on your own, make litigation strategies. Those are made in coordination with your client, is that correct?
That's true.
Okay. And can you see where, would you be handicapped or at a disadvantage in a case if you weren't able to share with your in-house counsel all of the material facts in the case?
I know that's a general question, Commissioner, and I know that I guess I'd have to review that on a case-by-case basis. In this situation, the material that in-house counsel is not allowed to see in Massachusetts is not crucial to developing litigation strategy. It's been proven not to be.
I mean, how do you know what's critical or not critical relative to the development of your opponent's litigation strategy?
What I know, Commissioner, is that there's been no appeal of this ruling in Massachusetts, and they have successfully litigated this case so far to date. They've had hundreds of discovery questions. They've had multiple pieces of testimony and surrebuttal testimony. There's been days of hearings that are going on currently where they have been fully cross-examining National Grid's witnesses. There's been no apparent impairment of their outside counsel's ability and their consultants to litigate the proceedings.
Sounds like a great case for all the lawyers up in Massachusetts. Okay, thank you.
Can you appeal interlocutory orders in from the Mass DPU?
They can go to the Supreme Judicial Court.
Okay, so the interlocutory orders, they don't have to wait for a final order?
That's, I believe that's correct. Any order from the Mass DPU, if I'm correct, can go to the SJC.
Okay, I wasn't sure if that law was the same as Rhode Island's.
Why didn't you object to NextEra's intervention in this matter?
Because National Grid realized, there is a, I guess this is more regulatory strategy, Chair, and at the risk of revealing attorney-client information. National Grid's understanding about intervention in Rhode Island is that Rhode Island doesn't typically keep out parties that would like to intervene, that there is a process by which would have to have gone through to object to have them come into the case. And the company made a decision that they chose not to object their participation in the proceeding. And the company's not objected to certainly providing their outside counsel and agreeing to their consultant so that they had full access to this information and could litigate in this docket, even though it's very clear what their interests are in the process.
Right, by the way, how many National Grid attorneys are you working with on this matter?
In Rhode Island, I'm working with Jennifer Hutchinson.
Okay. Are there other National Grid attorneys here today, though?
There are not other National Grid attorneys. I'm sorry. If I may, I'm happy to take further questions. Okay, sorry.
I didn't mean to. Does he still have time left? We kind of cut into his time.
And I'm happy to stop and let Algonquin's counsel speak, because the other issue I just wanted to point out to is that NextEra does have competitive interests that are at play here. But Algonquin, as the competitor of NextEra, is probably best to respond to that. So I'm happy to have Counsel Lehajan address that issue.
Good afternoon. I want to start by addressing three things that have been mentioned.
I want you to tell me first, why didn't you object to NextEra intervening in this matter?
I would say it's for the very same reason expressed by counsel here, which is that intervention is relatively permissive. They want to express a view regarding these proceedings. They participate in the energy markets in Rhode Island and New England. We understand that. They can express that view. I don't believe they're terribly handicapped in doing so by not having access to the limited information that we propose to be redacted. Now, I understand the Commission had concerns about the broad brush redaction on the initial filing. You'll see after we conclude argument on this motion that we've actually pared that back substantially. What we're talking about at this point is redacting pricing information. Pricing information is at the heart of APRA's protection for confidential commercial information. The exception to the definition of public records in APRA says that public records do not include trade secrets and commercial or financial information obtained from a person, firm, or corporation which is of a privileged or confidential nature. That's it. That's what APRA says about it. So we've heard a lot of discussion about the need for transparency and the specter of 38 studios that hangs over Rhode Island. But the fact of the matter is that the legislature is the party and the branch of government responsible for weighing these interests, and it weighed them when it enacted APRA. And what APRA says is that confidential commercial information is not public record. The public has no right to access to it. Rhode Island Supreme Court had opportunity to evaluate APRA's exception for commercial information and stated the following: that the argument that an agreement is a public record is that this argument ignores the fact that documents reflecting the give and take of arm's length negotiations obviously reflect, at a minimum, a party's offer, response, counteroffer, and the price a prospective customer is willing to spend for a specific service. Without regard to which party prepared the material, it amounts to commercial information not ordinarily made public. So what we're not talking about here, we are not talking about taking information that is generally made public and saying, in this proceeding, we're going to make a very narrow exception and keep it private. What we're talking about is information that is never allowed to be public as long as it is kept confidential. By filing a motion for protective treatment of this information here, National Grid has taken the necessary steps, and Algonquin has preserved this very information as confidential. So at the outset, given the memorandum of August 5, saying that the Commission would be looking at this through the lens of APRA, looking at it through the lens of APRA, it's a simple analysis that is, confidential commercial information is not public information. So what is NextEra's interest in seeing it, other than as an intervener in these proceedings? But as an intervener in these proceedings, it's not uncommon that there will be some material that is considered confidential. Now, going to the arguments raised by NextEra, I think first it's important to note, NextEra is not the guardian of the public interest. I know they would like to make that argument and wear that hat before you, but that is not who they are. They're a competitor, they're a business enterprise, they operate for a profit. Their interest in seeing this, and this is not to impugn them, they're a company in business, their interest in seeing this is not to protect the public interest, it is to protect their own. The public's interest is defended by the Commission, by the division, by the Lieutenant Governor's office. parties who have access to this information. What we're talking about here is a competitor of Algonquin's trying to lift up the skirt. Take a look. Now, the argument's been made that these are in-house attorneys and that they're ethically bound not to disclose this. And I don't intend to impugn any of their integrity or suggest that they would intentionally do so. But the fact of the matter is they cannot unsee information that they do see. Among the attorneys on this list, we have the general counsel of the company, presumably someone who reviews virtually every substantial contract the company enters into. How is he supposed to forget what was contained in this agreement whenever he looks at another agreement? When they decide to buy pipeline capacity from Algonquin, how are these counsel in drafting agreements supposed to act as if they've never seen the terms and the pricing of this agreement? How, in their participation in the Massachusetts proceedings, are they supposed to act and conduct themselves as if the commission had not given them access to information here that they do not have access to there? Ultimately, what this commission is doing is saying that these attorneys, because they're ethical, would never be able to use this information to the advantage of NextEra. But the fact of the matter is simply by seeing it, they're bound to use it to the benefit of NextEra and at the competitive expense of Algonquin. With that in mind, I just want to put in perspective the competitive interests here. NextEra is a competitor of Algonquin in the capacity of a bidder in an RFP in Connecticut, in which its renewables projects are directly in competition with Algonquin's proposed gas capacity contract. The DEEP in Connecticut is weighing all of these options together, and that RFP process is ongoing. They have not selected the successful projects, and when they do, they're going to be evaluated. There are going to be requests for information. There's going to be argument back and forth about approval, much like you have here. But there, these bids are under seal until approval. You've heard at some length about the Massachusetts proceedings where these things are being kept from NextEra's in-house counsel. So I won't reiterate those. Regionally, NextEra is a purchaser of pipeline capacity from Algonquin. It's a generator of electricity that benefits from high electricity rates that we are trying to curtail here. And it's an opponent of Access Northeast in every jurisdiction where it is currently under consideration. Now, I won't walk through the individual redactions because after this oral argument, I understand you'll see a revised redaction that pares it back substantially. But I think what you have to understand is that there is a harm to ratepayers that results from disclosure of this type of information. The harm to ratepayers is this, that in requests for proposals, the idea of a sealed bid proposal is that every party who is making a proposal puts their best foot forward. They sharpen their pencils and they make the best bid they can, and they hope that they get it. By unsealing information to attorneys, even if they're in-house attorneys who say, I will not disclose this, to the extent that they review that bid, what they're now inclined to do is what I will call a price is right bid. What's a price is right bid? If they know what Algonquin's bid looks like, the incentive of any competitor is to bid as much as possible without going over Algonquin's bid. So instead of sharpening the pencils and making the lowest possible bid in response to a request for proposal, you're now in a situation where if you bid simply $1 less than what you know Algonquin's bid looks like, you are going to be the successful bidder. In addition, parties like Algonquin might be, in the future, discouraged from participating in public requests for proposals because the competitive cost of having their terms of agreement, their pricing, put in public view, that competitive cost forces them to either say, A, I won't bid, or B, my proposal is going to account for the fact that in my future negotiations, I'm hamstrung by my competitors having seen my confidential pricing. Algonquin understands the need for transparency. We are not unaware of the controversy in Rhode Island the past few years. I can say this much with respect to at least 38 studios, a specter of which they raised. Even in those proceedings, when Judge Silverstein cracked open the Superior Court file for all the state, that was saved for one piece of information, and that was the confidential commercial information of Electronic Arts, the co-publisher of the video game that never came to be. He determined that that third party, a business party who had entered into an arm's-length transaction with 38 studios, that their pricing information was sufficient in terms of its sensitivity to say that will be maintained as attorney's eyes only. Now, understand, that was attorney's eyes only. That was information that couldn't be shared with parties. We've heard much today about being hamstrung in representation of your client. I can tell you as recently as Friday, when we were discussing this hearing, the redactions to the testimony the National Grid submitted could not be discussed on the phone with my client, because they're subject to the very same restrictions that NextEra is subject to. So with respect to the precedent agreement, which my client's a party to, that's information they already know. But we're equally disadvantaged by having to deal with the fact that the supporting testimony here can't be discussed with my client, notwithstanding we think we can effectively litigate this case. Much has been asked about how does a lawyer...
So can you explain what you mean a little more? I didn't understand, I didn't follow you on that.
Okay, so there's certain supporting testimony that was filed in connection with this request.
It's a National Grid's testimony.
Exactly.
Oh.
That is highly sensitive confidential information, which, in accordance with the NDA that we've signed, can't be shared with the in-house attorneys at Algonquin.
That's fine. No, I just wasn't following the...
A lot has been said about an attorney being hamstrung in the representation of their client. We have to understand that these in-house attorneys are just that. They're attorneys. So when the information comes into their hands, how are they any less hamstrung? Because they can't discuss it with the executives and the board of directors who actually make decisions at these companies. So they're in the same position as outside counsel. So there's actually no added benefit to disclosing it to them, other than that there are more eyes on it. If it can't be put up the executive chain, ultimately it's still just an attorney making a call on behalf of the client. Now, is that a bad thing? There are certain calls I can't make in litigation on behalf of my clients. There are certain calls that have to be made by the client. But that doesn't mean my client drafts deposition questions. That doesn't mean that my client drafts or evaluates discovery requests. And this ultimately is what we're talking about here. These models that are going to be run, we've heard today, the attorneys don't dig into these models, the experts do. Well, the experts have access to this information under the agreement as they are drafted. So there's really nothing that NextEra loses out on, other than a peek under the skirt of Algonquin's business. So as I said in opening, the General Assembly has weighed all these transparency interests, and they drafted APRA to address them. APRA clearly excludes from the definition of public records the pricing information here. It's at the heart of protection for confidential commercial information. There's no reason to disclose it to anyone here. Frankly, Algonquin would be more comfortable, if it were possible, disclosing this information to the public at large so they could evaluate it, if there was some way in doing so to keep it from falling in their competitors' hands. Because there isn't any way of doing that, our only solution is to keep it confidential.
Does the division want to argue it at all?
We do not have a formal argument, but I've made some observations that I could share. Number one, the division represents the public interest. They represent the ratepayers. NextEra is a for-profit company, and clearly, if they do own generation, they would be advantaged from seeing the effects of price suppression there. And finally, I agree with my brother that financial information goes to the core of APRA exclusions, and I've had experience many years ago with my brother to my right with the exclusion of financial information in Island High-Speed Ferry. So, for those reasons, I would just share those observations with you. Thank
you. Thank you, Chairman. Lieutenant Governor McKee has no formal position on this motion. Again, I will make a couple of brief comments as well, like my brother. I have experienced this in the past. There has never been any problem that I'm aware of in the 35 years of litigating dockets that I've litigated here with attorneys breaching their ethical responsibilities and disclosing information that was subject to a non-disclosure agreement. That being said, Lieutenant Governor's primary concern in this matter rests with protecting the ratepayers, especially the small business ratepayers. And with that in mind, the Lieutenant Governor understands that there is a reason why certain records are exempt from public disclosure under Rhode Island's Access to Public Records Act, which is what guides the PUC, of course, in this proceeding. We understand that certain information may need to be redacted to protect the ratepayers from unnecessary price increases due to unfair competition in the bidding process, which could result. Again, all of that being said, my brother is correct when he says that we have signed a non-disclosure agreement, and that the terms of that non-disclosure agreement allow outside counsel, myself, my partner, to see that information and allow our experts to see that information. And to date, we have not had any problem litigating the matter and getting direction from our client without discussing the confidential information. That being said, we take no formal position on the motion. Thank you.
Just have a couple brief comments. First, I agree with counsel, and I think I stated that at some point, that APRA certainly does provide protections, and that's not what Nextera is asking for. Nextera is not asking for the information to be put into the public record. But I think the implication that somehow the information would leak inadvertently into the public record is a misnomer. We are fine with the protections provided by APRA. I think that where it bleeds into a little bit to this argument from the Commission's sua sponte review is that National Grid has labeled almost everything highly sensitive confidential information, including information that flows from it. Now, we're not asking to put that to the public record. We're just asking that in-house counsel be allowed to view it to help assist with coordinating this litigation. Second, there was much made about Nextera being a competitor and not having pure interest, I suppose, in this docket. And it was said that Nextera has nothing to do with ratepayer interests, that they will benefit from higher gas prices. There was also the statement made that Nextera's only goal is to undermine the contract, and that if information is inadvertently disclosed, it will result in this deal not going forward, and Rhode Island ratepayers will be adversely affected. That completely assumes that this contract before you is in the ratepayers' best interest. And that's exactly what we're here to litigate and discuss. So to make this argument that the conclusion has already been reached, that this is advantageous to the ratepayers, defeats the purpose of litigating this docket. And while Mr. Hagopian may be correct that the division is a ratepayer advocate designated in this docket, this commission knows from past dockets that interveners absolutely raise other issues that the division does not raise. And so to assume that this is in the ratepayers' best interest misses the point. There was also the implication that Nextera has been able to successfully, was the word, litigate this in Massachusetts. Well, we'll never know. We'll never know because they have not been able to share information with in-house counsel. It's almost amazing to me that you would ask in-house counsel or prevent in-house counsel from reading full testimony of their own witnesses. That is not being able to successfully litigate. They were left in a situation with a decision made by the Mass DPU that was based heavily on Mass law and had to deal with the circumstances the best they could. That does not mean that this commission is bound by that decision or that they are successfully litigating at this point. They have not been able to see much of the information. And I think when we go to the next phase of this hearing, I don't even think counsel can sit with me while we look at redacted versus unredacted information. And quite frankly, that absolutely implicates my client's due process rights. My client was allowed as an intervener. There was no objection filed. It's my understanding there was no objection filed in Massachusetts or New Hampshire to Nextera either. So I don't think it was a strategic decision made specific to this commission. because this commission is somehow permissive. There were no objections filed in other places.
Although, are you saying that simply because a party has been allowed to intervene in a matter, that then there can be no rulings protecting commercial information that would otherwise be confidential, has to be turned over to?
No, absolutely. And the APRA absolutely does protect that from entering the public record. And just, I want to make clear, we are not advocating putting that information into the public record.
I'm not talking about public record. I'm talking about, are you saying that in no proceeding can any party be denied access to information that's ruled to be confidential, commercial information that would not ordinarily be disclosed?
I'm not saying that, Commissioner, and what I am saying is a practice that this commission has been, that in fact, certain parties, certain companies cannot have access to that information. But I have never heard, and I think that Commissioner DeSimone echoed it, Attorney McElroy, that never has there been a prohibition against an attorney who is willing to sign a non-disclosure agreement from seeing that information and being able to direct litigation. And that is a very, very dangerous precedent, I believe, for this commission to allow that.
But if a determination is made that certain information should be protected and should not be disclosed, why, and thus shouldn't be disclosed to another party, why doesn't that mean that, and that should include the party's attorneys?
Because the attorneys are bound by the non-disclosure agreement, number one. Number two, I think the question was asked, how are their attorneys supposed to act and conduct themselves if they see this information? Well, quite frankly, how am I supposed to act and conduct myself when I see this information? And I'll tell you, it's according to the terms of the non-disclosure agreement. How is Compass Lexicon supposed to act and conduct themselves when they see this information? According to the terms of the non-disclosure agreement. And that is exactly what in-house counsel would have to do. Conduct themselves with respect to the terms of the non-disclosure agreement. We're not talking about the in-house attorneys having unfettered access to this information without any protection. They are absolutely subject to the non-disclosure agreement. And I understand that there is a line that has to be drawn somewhere. And that line is that in-house counsel cannot share it with anybody on the business side, that it is restricted. We've offered to restrict it even further to a smaller subset of attorneys. And so those attorneys would handle the information according to the terms of the non-disclosure agreement. So I'm not saying that the commission doesn't have any authority. They clearly do. And clearly the APRA prevents this information from entering the public record. But we've now gone another step further in hampering an intervener's ability to litigate. And I don't think that a line should be drawn, once an intervener is in, I don't think a line should be drawn that you have less of an interest than somebody else. If an intervener is in, their counsel should be able to review that information subject to the non-disclosure agreement.
Chairperson, could I ask a question if either Mr. McElroy or Mr. Hogopian? Mr. McElroy, when when Island High-Speed Ferry was in for its initial rate case, and Interstate Navigation was a party, did you have access to Island High-Speed Ferry's financial information that went into its filing? Do you recall?
That was at least 15 years ago.
It was more than that.
I honestly don't recall the details. But I do know that we did have a full rate case. I know that we analyzed all of the information. And I'd like to say that I believe we had access to all the information. But I can't honestly say that I can recall that, because I don't recall ever having litigated the issue, saying that we don't have enough information in order to be able to move forward. Certainly, my recollection was we felt we had all the information necessary to be able to move forward.
Mr. Hagopian, do you recall if Island High Speed Ferry had to turn over all of its information to Interstate?
My recollection is that we did enjoy some protection of our financial information. So.
Okay. It's okay. I just figured I had you in the room.
It was 1998, but as I recall, I think we did enjoy some protection from disclosure of financial information. In subsequent cases, we had some subsequent cases where there was access allowed to an annual report. But I think that was the extent of it, which showed the gross revenue.
Okay.
Can I just say something on that point? Since you asked, I can, and I said this before, in the Deepwater case, all the information was shared. It was not put in the public record, but as long as the party signed a non-disclosure agreement, that information was provided to them.
And I wanted to ask you about that. As I recall, in Deepwater Wind, there was only one bidder.
I don't believe, there may have been at that point, but there was definitely,
And there was only one contract in place.
and there was a lot of confidential financial information that was freely shared among the parties, although absolutely the commission, in fact, if you will recall that docket, the commission, Deepwater ultimately put the information in under a request for confidentiality, which was then addressed at the hearing, and the presiding commissioner denied the motion for confidentiality initially, and then allowed it. But absolutely, there was no restriction on any party or attorney receiving that information as long as they signed a non-disclosure agreement. Anybody could have it, objectors, interveners, anybody could have it as long as they signed the non-disclosure agreement.
But in that case, there was really no competition to Deepwater Wind at that stage.
There's 2 points to this, though, and this is what I think is getting lost. NextEra is not a bidder. They haven't bid on any of these pipeline projects. They're not a bidder. And certainly in Deepwater, had their financial information been shared into the public, had the proposal been denied, that information could have been used by competitors. And all that was required was that you sign a non-disclosure agreement. There was a presumption that if you signed that non-disclosure agreement, you would abide by it. And it wasn't just attorneys. It wasn't just attorneys in that case.
Doesn't that happen in scores of cases in Superior Court or Federal Court where the litigants are business competitors?
Absolutely. There are provisions put in place, but there's not an absolute block or prevention on a party seeing that information. And that's what we're talking about here.
So I had one other question for National Grid. I noticed that in the request for protection and for the commission to find that the information for which confidentiality was requested would fall within the trade secrets, commercial financial information, that was the exemption upon which the company relied in seeking the commission to find that it's not a public record. I noticed that the company did not cite any records which would not be available by law or rule of court to an opposing party in litigation. And I know that the confidentiality agreement is with another party and that you're turning that over. But it seems a little odd that that not even one attorney, one in-house counsel could reasonably or fairly or safely be included for Mr. Keogh to consult with. And you know, being sort of almost the equivalent of in-house counsel, I suppose, you know, I think it would be very challenging if we were to hire outside counsel and not be able to talk to them.
So if I may respond, I certainly acknowledge on behalf of National Grid that what National Grid is asking for here doesn't have widespread precedent. It has a very precedent in Rhode Island, and it has precedent in Massachusetts, but in a very similar circumstance as what we're talking about here. And I acknowledge that. And I certainly understand Nextera's arguments and their need to try to get at this again in Rhode Island, where they tried in Massachusetts and lost. Discussions can take place between outside counsel to Nextera, inside counsel to Nextera, and even business folks at Nextera. They just can't reveal the negotiated rates. They just can't reveal specific aspects, which we'll go through after we have this argument, about some benefits that are going to come to National Grid customers that are related to the negotiated rate that was agreed upon. Counsel is, and I know there's other questions to this effect, and there's a suggestion that somehow outside counsel is hamstrung to communicate with the client about this information. Counsel with experience, which we have here for Nextera in both states, can absolutely articulate strategical questions, issues related to the litigation, issues that relate to interpretation of what one side might be advocating in a case, without specifically revealing discrete levels of confidential information. And all I can stress to the Commission in this instance is that the balancing here is all about the ratepayers and all about ratepayer interest. There was some discussion about sharing information with Nextera in-house counsel and how that might come up on public record. I think that's probably unlikely that information would be unintentionally revealed on the public record if Nextera in-house counsel gets this information. What National Grid doesn't know is whether or not Nextera in-house counsel, when they get this information, do they have responsibility over other business transactions for Nextera that might involve information that they will see from this docket that they can't unknow once they see it, and have that permeate into either current solicitations that are ongoing right now in New England, or other solicitations that might happen in the future to the extent that this deal doesn't go through. And Algonquin decides to put forward another contract, negotiate another deal with parties for their pipeline capacity. Once in-house counsel knows this, if they are responsible for information and reviewing deals that might, where this information might be advantageous in Nextera, they can't unknow it. And so the line that was drawn in Massachusetts was that outside counsel can see it, expert consultants can see it, but to the extent that there's a full party to a docket, that is a competitor to the party that's trying to withhold the information. That an attorney's only prism be imposed in that situation. And in both the 0764 docket in Massachusetts, and I could describe the details there, but I won't bore you all with it, and the details in this docket, at least the Massachusetts DPU understands the risks that could come from that information getting into the hands of business interests at Nextera.
And just a couple of questions for Algonquin's attorney, and I should have asked you before. On page 11 of your filing, paragraph 28, you referenced the New Hampshire proceeding. And you state that the New Hampshire Public Utilities Commission has thus far maintained the confidentiality of Algonquin's confidential commercial information in its proceedings to consider approval of the proposed agreement. The New Hampshire Public Utilities Commission proceedings are in the early stages, and Nextera is actively advocating against approval of the proposed agreement there. What is the point of that? What is the point? What point is that proceeding at this point? Has anything changed since the filing of this? Has the New Hampshire Commission made any decisions?
Nothing has changed as far as I know. I didn't check the docket after this was
And who is the electric distribution company in New Hampshire that's,
Sorry, I don't recall myself. I'm not involved personally.
okay, so it's, do you know? And so does
I believe it's Eversource.
it is Eversource, okay. Is Eversource seeking the two-tiered approach in New Hampshire?
I do not know one way or the other if they are. I do know that they're seeking confidential treatment, I just do not know as I sit here whether or not they're seeking the two-tiered approach.
Okay, does Nextera know if Eversource is seeking the two-tiered and what's going on in New Hampshire?
I have to say, I can't recall if their initial confidentiality filing specified it. In Massachusetts, the issue didn't come up until we asked for the information, so I can't recall if in New Hampshire they put it in their initial filing, but the Office of Consumer Advocate in New Hampshire is opposing having any of this information be confidential, so they're advocating having it all be public. Our position there will be the same as here, as long as we can get the information, however the commission wants to handle the public disclosure, that's not an issue that we get into. But the New Hampshire proceeding is still at the stage where they're trying to decide, is it legal under New Hampshire law? They haven't gotten into evaluating the application yet.
Okay, thank you. And I'm trying to ask questions that don't blur the two particular issues. But the argument is that the information being kept from in-house counsel is related to pricing and inputs into pricing, and that this is important for ratepayers. But even the ratepayer impact in this case is not truly public. There's a lot of confidential information contained within things that have never been non-public, at least since I've been here, and I can't find any orders where real calculations of ratepayer impact and inputs are confidential. And so I think, and maybe it's starting to blur the line a little between the two issues, but I think that a question, that's one, I'm not quite sure how to phrase the question, but is there a standard for what is confidential financial information? So the APRA says it has to be of confidential nature. So what makes this particular information of a confidential nature that it would harm Algonquin, harm National Grid, if Nextera receives this particular information? Like, what makes it confidential? What makes it it's all blacked out?
Sure. So, and we will certainly discuss this more when we talk about redaction, but I think it's pertinent to this discussion. Happy to talk about it now. The reason why some of Ms. Leary's exhibits have redacted information is because you can back into the negotiated rate by revealing there are two factors that go into the net benefits and the calculation of what would be a credit for customers in Rhode Island. To reveal that information, which we can explain in that second phase, would allow somebody to back into this negotiated rate. And the negotiated rate, the way these pipelines work, and I'm certainly referring this to reaction if I misspeak here, there's a tariff rate typically, because these pipelines are FERC jurisdictional. And that tariff rate, the pipelines can go out and have customers come in and pay that tariff rate, and that rate would only change over time when base rate cases are filed at the commission. In this instance, similar to special contracts, there is a negotiated rate that is different than the tariff rate that Algonquin has. Whether they put forward it at FERC right now or they will, I don't know specifically, but regardless. This rate is negotiated at a point that is more favorable to customers, that National Grid believes, than what they otherwise might be getting through the tariff rate. And with other provisions that relate to benefits to customers. And so if that negotiated rate is revealed, that's the bogey that other competitors to this project can use to price their project, to price their project at that $1 below what Algonquin and National Grid have agreed to in this instance. Not to the extent that this all dissolves, not the lowest price that they could pay, but just a little bit more favorable potentially than what was negotiated here. And that's the whole purpose behind that trade secret protection in APRA, is to make sure that when utilities in Rhode Island are subject to and are required to go through competitive solicitations to get their services, electricity or gas for customers, that the competitive solicitation is vibrant and will result in the lowest price possible for customers. And that's what keeping this information protected accomplishes.
I don't have any other questions, just an observation. I know at least one attorney wouldn't be able to back into that type of.
And believe me, Commissioner, it's less about a layman or even an attorney backing into it. It's competitors of Algonquin backing into it. They can absolutely back into this information with the right information revealed in the public record.
That's assuming, however, that the in-house counsel violates a non-disclosure agreement, isn't it?
It assumes whether the in-house counsel purposefully discloses this information or not, or even unintentionally discloses the specific information, is something that I would certainly acknowledge is probably unlikely to do. With that information in their head, as they're looking at other deals, what does that attorney do? Can they use that information and not violate the non-disclosure by not revealing it to anybody? They certainly can. That's the risk. That's the risk that National Grid, and I believe Algonquin certainly, is trying to protect against.
They can in the court, or in this instance, the commission would expect them to abide by the agreement that they signed. Isn't that correct? Doesn't this happen in every day? There are cases, commercial cases, in the courts where there are non-disclosure agreements, and it's always the case that outside counsel and inside counsel sign the non-disclosure agreements, are given access to the information, and the court expects them to live up to their word. They sign that non-disclosure agreement. They're subject to disciplinary proceedings, complaints, etc. And yes, in all of those cases, they could, if they chose, violate the agreement and speak to someone on the business side. But we expect them not to. Isn't that the case?
So, Commissioner, I certainly agree, but that analogy, with all due respect, is inapt. In that situation, the court is litigating, in those instances, the commercial interests of two parties with at-length negotiation. And to the extent that information is disclosed in that instance, the party that's hurt, there's a financial implication to it. The Commission's responsibility here is to the ratepayers. This isn't about a situation where you can analogize this to Superior Court trying to enforce non-disclosure agreements. This is all about protecting the risk that ratepayers are going to be harmed if the information gets out.
But those contracts could also, those competitors could also be contracting with public entities. We could be dealing with construction contracts for road building, etc., where the taxpayer could, like in this case, be potentially damaged if there was a violation of a non-disclosure agreement. Isn't that true?
To the extent that one party to that contract happens to implicate taxpayer interests, it could be true. All I'm suggesting here on behalf of the Rhode Island PUC, the Rhode Island PUC's role here is to protect the ratepayers that are going to be paying for this contract. And in this instance, the decision, I do believe, is for the PUC to make a determination whether or not that risk, that this information could somehow be used to the competitive disadvantage of Algonquin and National Grid, and could somehow adversely impact the costs that customers would now pay for this contract, or adversely impact the potential benefits that we certainly have the burden to demonstrate to the Commission are inherent with this contract. And so whether or not in other contexts attorneys are anticipated to be enforcing and implementing non-disclosure agreements, I absolutely have to, you're absolutely right, that's absolutely true. And they would have to here also. It's the commission's role, in my opinion, to weigh the risk of, in this instance, having the information adversely affect.
Couldn't it also be the case that a vigorously litigated case in this proceeding may be in the ratepayer's best interest?
And there's nothing to suggest that won't be a vigorously litigated case in this proceeding. There's nothing that has been said today that demonstrates that Nextera is going to be adversely impacted by the protocol that has already been put in place for Nextera in Massachusetts and that they've already been working on.
Thank you.
Is Nextera, if this motion were approved, what, if any, protocols have or will be put into place within the legal department now and going forward in order to address the types of concerns of you looking at a contract in 3 or 5 years and saying, hey, wait a minute, I remember reading that material and here was the rate. What protocols are being put into, or would be put into place? Or would you have that in your head?
I think the first thing is the limitation on the attorneys who would look at it on a need-to-know basis. We have a specific reason why all these folks would be involved. Myself, I don't, I'm a regulatory attorney, so I advise on state utility proceedings. I don't advise on business terms. The NDA itself requires that we return the information upon request at the end of the proceeding. We would absolutely abide by that. The other provision in the NDA that I thought would be helpful that I don't have at my fingertips. There's no photocopying or reproductions of the information, and National Grid can correct me if I'm wrong, but I interpret that to mean no physical copying, but then also if we get a thumb drive or a CD, we're not to save it to a computer. So that would mean that that information is just on whatever form that National Grid gives us, and we keep it locked up and not discuss it with business folks.
Does that mean you also couldn't take notes of your own directly from the material?
I don't know the requirement in the NDA on that off the top of my head. I'm not sure if the National Grid does, but I'd have to look at that. And certainly, if we were able to take notes, we could keep them segregated with the information that National Grid gives us.
I'm just wondering how it would be different if you just hand copied the otherwise redacted information. Why is that different from photocopying?
I think that material would have to be either destroyed or returned as well, and I don't think there'd be any objection to that. I know most NDAs that I've signed that it's, and I have to reread this again, but it's usually that the materials themselves and any materials created from those have to be either returned or destroyed, which I don't think would be an issue here. So that you're right, you're not keeping notes on them. So there's no, I think that is implied too in the no copying, that you couldn't sit there and like Bartleby the Scrivener, write it down. But I think that would come under the umbrella of destroying any materials produced by National Grid or any materials, including notes or memoranda from Nextera.
So, Ms. Jameson, you said that you're a regulatory attorney?
Yes.
Okay. And what do Mr. Murphy and Mr. Lavarco do again?
Mr. Murphy is, he's also a state regulatory attorney, so he's also involved in proceedings similar to this one and others before state utility commissions. He's not a advising on business terms. Mr. Lavarco is our FERC in-house attorney with expertise on gas matters. He does work on gas pursuant agreements, none that pertain to the Algonquin pipeline or others under development.
I guess what I'm trying to get at is a scenario, if, I don't know, if the commission were inclined to rule one way or the other, if, I mean, I look at this list and you know, my gut says vice president and general counsel is a little uncomfy.
Yeah, and that's why we offered up taking him off, because.
And I think director of regulatory affairs, I'm not entirely sure what her need is on that. And I really think director of regulatory affairs is somebody whose sole role is to say what's going on in each state, and that would be a very difficult role to play and follow the NDA.
Well, she's not to clarify, she's not working on commercial terms in various states. She's working on ISO New England matters and proceedings such as this one in the States. So she wouldn't be helping to negotiate terms of a gas contract.
And I guess what I'm trying to get at, though, that even with that, what are there protocols that would be put into place to ensure that there wouldn't be a future use of this information, even if you don't have it? But just that whole idea that you can't unknow it, you can't unsee it. It's there. I understand institutional knowledge has value, and so what would be put into place to ensure that NextEra couldn't use this against Algonquin later or in a commercial situation? I think that's maybe what I'm trying to get at. Now, I don't know, maybe they're going to rule against you, and this is not the best time.
So I think that the NDA says that we can only use it for purposes of this proceeding. So I think, and I understand the view of you can't unknow it. I think that presumes there's a situation, a realistic situation where this would be a competitive help to NextEra. And to be clear, we did not bid on in the RFP in Massachusetts and the issue here for Connecticut. I'm not aware of any other, I think Algonquin's attorney mentioned NextEra buying capacity on the Algonquin pipeline. I'm not sure what he's referring to, but also don't understand how understanding this price and being able to talk about what our model results in for cost and benefits has any bearing on capacity contracts that presumably, under this proposal would be worked on by a capacity manager. And so I guess partly I'm struggling with how do they think we're going to use this? I still am a little bit unclear on that. And then beyond that, the attorneys we're talking about don't negotiate pricing. And so we're bound to not share that with those people who do negotiate pricing.
May I respond just briefly? With all due respect, there's nothing to stop NextEra the day after these particular attorneys get this information from being promoted, from being transferred from the job within NextEra, where they have direct responsibility over this information. And I know Attorney Jameson is certainly sincere when she's saying right now, she's trying to articulate why they may not. Nothing prevents that circumstance from changing 5 minutes after they get access.
The NDA is in place.
It could be hired by National Grid too.
Do you want to take a short break to allow our center to also have a short break?
We will take a short break. 10 minutes? Do 10.